All rise. Court of Appeal for the 5th District of the State of Florida is now in session. The Honorable Vincent G. Torby Jr., Judge, presiding. All persons having business before the court draw near, give attention, and you will be heard. In God's sake, the United States of America, the State of Florida, and this honorable court. Please be seated.
All right, good morning, ladies and gentlemen. Welcome to an oral argument session of the Court of Appeal for the 5th District. Let me announce a panel change. Judge Evander was ill and could not attend oral arguments this morning, and Judge Lawson is attending in his stead. Judge Jacobus, to my left, to your right, is the other member of the panel. If anybody's got a cell phone or some kind of device that makes noise, please double check it to make sure that it is on silent mode. You'd be surprised how many times we say that and yet somebody's cell phone goes off during an oral argument. We'll take the cases in the order they appear on the docket. If anybody's here on Torres versus Washington Mutual, that oral argument was dispensed with on that case. So the first case that we'll be proceeding with is the Johnson Law Group versus Springs Equity. And if the appellant wants to reserve anything different than 5 minutes, you'll have 20 minutes of time on the clock. If you want to reserve anything different than 5 minutes, let me know and I'll set the clock accordingly. All right, you may proceed on behalf of the appellant. Before you start and before I start clicking away on your time, we did get a motion to continue from you. And we noticed that there was two lawyers that had actually, whose names were on the brief, initial brief. And, that's a representation by the court that any of those lawyers are prepared to handle oral arguments. And we typically don't grant continuances under those circumstances. I'm just letting you know for your edification.
Thank you, Your Honor. And I thought about asking Mr. Moss to be here in my stead, but a date with the 5th is something that I'm loath to miss.
Yeah, and the motion didn't really address his inability to handle the oral argument, so that's pretty much why it was denied. So,
I appreciate the insight. Thank you, Your Honor.
All right, go ahead and proceed with your argument, sir.
Thank you, Your Honor. Good morning. May it please the court. The 5 minutes for rebuttal will be fine. Thank you, Your Honor. My name is Nick Shanine, and I represent the appellant in this matter, the Johnson Law Group. The Johnson Law Group is the defendant below in a case where summary judgment was granted taking out their affirmative defense of constructive eviction with regard to a commercial lease. Because this matter was determined on summary judgment, the review by this court is, of course, de novo, a fact that has been stipulated to by the appellee. The key facts of this case are that the Johnson Law Firm leased office space from the landlord.
What do you think the effect is of the statement that we are seeking immediate termination of the lease agreement?
Your Honor, that statement, you have to read it in context. Right. That's the important thing about that statement, that the full two-page letter clearly did a few things. It set out the number of disputes that the tenant had with the landlord regarding the habitability or the tenantability of the premises for that purpose. And it set forth the numerous times that it had contacted the landlord, but now it was stating it in writing. But the most important thing is that by following that statement regarding immediate termination was the desire. We are seeking immediate termination of the lease agreement. It followed that up with this statement. We are prepared to take any and all necessary steps to terminate this lease agreement. We will vacate the premises on or before February 16, 2009. The letter having been written back on January 8, 2009. Thereby, when you take the letter in context, it's clear, had they simply written the letter that said, we immediately terminate, we're out, that would be a clear breach, and they would not have the right to say what they're saying as far as whether or not the provisions of the lease 22D apply to this case.
So they gave them, they had the 30 days de facto.
That's correct, Your Honor.
And you're saying that the modification of in that sentence, it doesn't read, we hereby immediately terminate the lease. it says we're seeking the immediate termination. So your argument is that the seeking says that, we're basically asking for it.
That is exactly correct, Your Honor.
That was the first written notice, correct?
That is the first written notice.
And that went to the business, or the manager, right? The building manager?
It did go to the property manager, and the property manager has made a number of statements on the record that reflect her prior knowledge of these matters, and most of the case law that precedes.
But isn't the problem that the contractual notice was supposed to go to the lessor, and it didn't?
That is technically correct, but as with all agency principles, the agent can act for the principal. And in this matter, that's not the reason why the court granted summary judgment. The court granted it on one basis and one basis only, and that was this: that it must be stricken for failure of the tenant to provide the requisite written notice as required under Section 22D. And then when we refer to Section 22D, it discusses that unless and landlord shall not be deemed in default of the performance of any obligation required to be performed by landlord hereunder unless and until it has failed to perform such obligation within 30 days after receipt of written notice from tenant to landlord. If you look at that provision, it's not, all that had to happen was that they have at least 30 days to remedy a situation that they're notified of and not do it. And that is what occurred here. So by the plain terms of the lease, a plain meaning interpretation of the lease, the landlord didn't do it. They could have done it. They easily could have cured the situation.
What I'm struggling with is how, even if you count the letter to the building manager as a letter to the lessor,
Sure.
how this would have put them on notice if they needed to do anything, because it says, you have constructively evicted me, you are in default, I'm terminating the lease, and I'm leaving. And although you can sort of, eke out that, well, it could be read as giving them a chance, it certainly is a stretch to think that a reasonable person would read this and say, oh, they're giving, this is a cure letter, I'm supposed to have 30 days to do anything. I mean, I'm struggling with that.
Again, Your Honor, if that had been the intention of the letter, if the letter had intended to say, we immediately terminate and we are out, the letter would have said that. Why give over 30 days between the date of the letter and when you intend to leave, unless that opportunity is there? And of course, the landlord had that opportunity to cure, not just at this point in time, but at several points in time before. The property manager testified that she had received 2 different quotes from someone to fix the widely vacillating temperature problem, and on both opportunities presented it to the landlord. The landlord said, nope, not going to fix it.
Is the tenant required to, under the lease agreement, is the tenant required to advise the landlord that they have a right to cure?
There's 2 parts to that. Part 1 is that the lease provision only requested that they provide written notice, and that there were 30 days between the date of the written notice and when they could have cured it, regardless of whether or not the letter has magic language regarding, please cure this. I do believe it would be reasonable that would be implied in that. And regardless, there are other tenants in this building that need this matter cured.
Was your answer to my question? No, I mean, it was actually a helpful question.
I apologize, Your Honor.
Yeah, I mean, it doesn't, right? I mean, the lease doesn't say you gotta affirmatively tell the landlord about the right to cure. It just says you gotta let them know of the deficiencies, and they have 30 days to cure, right?
That is correct, Your Honor.
Counsel, when you get a question where, that is calculated to help you, you gotta help me.
I'm normally adept at recognizing softballs, Your Honor. I whiffed on that one.
All right.
Sometimes it's hard to figure out what the helpful questions are, though.
Especially for me, right?
I agreed, Your Honors, and the recount went late yesterday, and
I understand.
And of course, each of these arguments are focused on whether or not that lease provision was adequately satisfied, as Judge Torpy just indicated.
Right, but then you have other arguments. Go ahead.
We do indeed, and the other argument's actually, perhaps from a legal theory concept, more interesting, only because it's no longer factual based. It gets to the root of whether or not this statute, 83.201, fundamentally altered what had been a century's worth of jurisprudence regarding whether or not a tenant has multiple remedies when faced with a landlord who's simply not doing what a landlord needs to do to make sure that the tenantability of a location, it continues to be what it needs to be for the intended benefit and use of the tenant. And that's something that simply has not been answered by any case subsequent to the enactment of that statute with clarity. There's no question that prior to the enactment of the statute, the legion of cases, Hankins v. Smith from the Florida Supreme Court being the leading one back from 1938 and forwards through Richard v. Dodge, Barton v. Mitchell, and even this court as recently as 1990 with Bermuda Avenue Shopping Center versus Rappaport, 560 Southern 2nd 805, where that court said that the constructive eviction was to be affirmed where the tenants had simply walked away. They walked away from the lease, and this court ruled then that the act, which had the effect of essentially interfering with the tenant's beneficial enjoyment of the leased premises, was enough. So it's clear prior to the enactment of the statute that if you weren't trying to get some affirmative relief out of it, that you're simply walking away was a possible remedy. Now, the courts of Florida had said that you got to do so with caution. The Bass v. Willits decision from the first DCA is a wonderfully instructive decision, 384 Southern 2nd 704 from the first DCA in 1980, because it goes through the analysis of the dangers to a tenant who elects to do this, who elects to walk without any notice at all, because that decision could be deemed to be a waiver if they had endured those conditions too long. And all of that, though, as the court noted then, it went to issues of fact, and it's up to the trier of fact to resolve it, and that's what this case should have done. It's not whether or not my client was wrongfully evicted or whether or not the landlord might ultimately prevail. They didn't get a chance to find out. They didn't get a chance to have their day in court, and that's where this case went astray. The only decision that really actually talks about this statute and goes with the theory that's now espoused by the landlord that this statute has changed it, and all the cases prior to 1993 should be essentially discarded, and we should only look forward from there, is a case by this court which is a per curiam affirmed decision. Alexander versus A. Bionks, 840 Southern 2nd 305, was a per curiam affirmed decision, but a per curiam affirmed with a dissent. And that dissent by Judge Harris provides a lot of really good discussion about the statute and about how wrong it would be to interpret it in a certain way. The problem is the landlord then takes the attempts to find logic in the axiom that, well, if the dissent said this, then the majority opinion must have thought the contrary. And of course, we can't glean that. That is the inherent difficulty with a PCA that includes a dissent. The dissent gives us some working information, but the PCA may have been granted on procedural grounds. There could have been a transcript issue. There could have been a preservation issue. There could have been any number of reasons why the two in the majority elected not to go with the dissent, and the dissent is left speculating as to what they might have been ruling on. So it is our position that this case either can be cited either can be used for one of two things, and the one would be to attempt to do this logical juxtaposition, and that's incorrect. You can't do that because we cannot know that that's why the two majority opinions said what it did. Or you can use it to say, well, we don't know why the majority went with what it did, but there's some logical stuff in here, and Judge Harris's decision makes a lot of sense, and most particularly was his focus on this, that the statute says specifically in the statute, this section is cumulative to other existing remedies, and this section does not prevent any tenant from exercising his other remedies. Plain meaning of the statute, it's simply the way that the statute should be interpreted, in our opinion, and we thank the court for its time and would reserve the rest of my time.
All right, so you've got a little over 8 minutes for rebuttal.
Thank you.
Before I start the clock on you, you're to be commended for the way you reacted to his request for emergency motion, that you communicated with him quickly and that you articulated your opposition, albeit not a strenuous one, but
Thank you, Your Honor. Yeah, we
I
would have been
commend you
happy
for-
to come back at a slightly later time, but certainly
Right.
wanted to get the show on the road.
We certainly understand that. All right, go ahead with your argument, counsel.
May it please the court, my name is Stacy Ford, and I represent the Appalachia Springs Equity LTD. Getting directly to the letter, because your honors have asked a lot of questions about the letter and the language of the letter in particular, a couple of things I want to note. First of all, in addition to the language talking about seeking immediate termination, the letter also says that they are declaring that Tricor, which was actually the manager, not the landlord, is in breach. And that is a definitive statement that a breach has already occurred.
Where is that part?
That is at the very top of the second page of the letter. It's I think the last sentence in there.
Well, I mean, according to their theory, that was a breach. Whether it's a default or not depends on whether they cure it within the period of time that they're required to cure it, right?
Well,
Isn't there a difference between a breach and a default?
perhaps, Your Honor. Some contracts list out what an event of default is and will include that a breach of a contract is a default. I don't believe that this lease did, and in the absence of that, I would equate the two.
Well, but I mean, what this lease says is that a breach of the lease is not a default unless notice and opportunity to cure, or unless they fail to cure it within the 30-day period after written notice, right?
Right. And to move on then to other language in the letter, one thing in particular I want to point out is that the letter says that they will vacate on or before a certain date. And appellant makes a lot of noise about the fact that that date was more than 30 days from the letter, but that on or before language I think is important. They were basically indicating, we're going to leave any time between now and that date whenever we find it convenient. We will vacate, they said. They did not say, we will vacate on such and such date unless you cure it within 30 days. They did not say...
Let me ask you this. Let's just see if you agree that the lease does not expressly provide for a particular form of notice.
No, it does not. It does not give specific language.
Now, if the tenant had said, you're in breach because of X, Y, and Z, that's good enough, right? They don't have to tell the landlord, you got 30 days to cure it. If you don't cure it within 30 days, blah, blah, blah. In other words, they have to give the notice, and the landlord has the time, because the lease says the landlord has the time to cure, right?
Well, under a different scenario, if the letter had said, these are the issues, these are the problems, we find them to be a breach, and stopped there, perhaps. This letter didn't say that. This letter said, we will be vacating on or before such and such date. So they were indicating that, in fact, the letter went so far as to say, we declare these non-repairable.
So you're saying that is repugnant with the opportunity to cure, in other words?
Yes. But I would go further and say I actually do believe that the letter should have indicated to some extent that a cure period existed. And the reason why I say that is even the case law that the appellant is relying upon, going back to the later case law, including this court's Kaplan decision, talks about written notice and a demand for rectification. That phrase, a demand for rectification, shows up in the case law quite a bit. As well, the new statute, well, I say new, I guess in the 90s is not so new anymore, but the statute even indicates that in addition to giving written notice, it must give the landlord at least 20 days to make the specifically described repair or maintenance, and stating that the tenant will withhold rent for the next period. So even the statute requires more than just a statement that these are problems. And I think that's important because, it's important to a landlord to know the difference between, we find this to be a breach, and we find this to be an untenable situation in which we're going to declare constructive eviction if you don't cure it within 30 days. The letter itself actually does not even state constructive eviction anywhere in it. There's no indication that that's what they're moving forward on. The letter says that there is a breach of Section 29, which is the express covenant of quiet enjoyment. Even that express covenant requires that it be subject to the lease, which includes the notice provision. So as I said, even the case law indicates that there must be a demand for rectification. So I would argue that there did need to be a demand for a cure.
Does the record reflect whether the construction activity in the next door suite continued after the 30 days?
The record does indicate that the construction next door ended about a week, if my memory serves me correct, about a week after the letter was sent. And I believe I do even have a
So
citation.
that was cured?
I'm sorry?
So that issue was cured?
That issue apparently was cured, yes.
And I guess if the tenant doesn't need to tell you that they're giving you an opportunity to cure, maybe you don't need to communicate that you've cured, so.
I'm sorry, Your Honor.
So I guess if the tenant doesn't have to tell you that they're giving a cure notice, we need this cured, maybe you don't have to tell them that you have cured. But was there any indication that I guess they would know, they were still there, that had stopped, the construction activity had stopped?
Well, the testimony, as I recall, was from Mr. Johnson himself, and he testified that the construction period lasted about 6 weeks. It started in December and ended about mid-January. And I do believe there was a citation in our brief to that language. So the construction did end within a week. And noticeably, the construction was something that fell within another term of the lease, and we cited that, I believe it was like the very last page of my answer brief, that there is a provision within the lease that basically says any construction we do within the building that will have no liability, and the tenant's covenants under this lease will not be reduced for any inconvenience, annoyance, interruption, or injury to business. Now, that was not an issue that was argued below, and I readily concede that, but under Tipsy Coachman, we did argue it in our brief, that as to the construction, there's just no grounds for declaring a breach and constructive eviction.
And then on the other issue, the letter says that on extremely cold days, that they had to use space heaters, and extremely hot days, they had to use fans or something to that effect. Did either side research whether that's sufficient to constitute a breach of the covenant of quiet enjoyment, or to be sufficient that it would allow, under the old common law, constructive eviction?
Certainly, we were prepared to go to trial if necessary on whether these circumstances even constituted constructive eviction. And there is in the record a pretrial statement that summarizes the issues that would have been addressed at trial. And I just happened to read it a couple days ago. I recall that in addition to indicating that we contested, of course, the circumstances, the facts that they alleged as to these supposedly intolerable conditions, we did intend to contest as well whether those even constituted intolerable conditions justifying a constructive eviction. But we didn't get that far, because as the lease clearly provided, and this is, I want to emphasize, this is a commercial lease between sophisticated parties. You know, we have a law firm on the other side, in fact. Both sides contracted to include a term that said, if you're going to declare that there is a breach by the landlord, you have to give us 30 days written notice, opportunity to cure, and that just wasn't provided here. The letter that was sent was very clear. We're leaving, period. In fact, Mr. Johnson stated in his deposition that it wasn't a threat. It was just his position. Another point, he said, this is how it is. That's what I was indicating. And, excuse me. I go back to the fact that both the statute and the case law suggest that a demand for rectification is necessary. Now, we also cited numerous cases in our brief that indicated that strict compliance with notice requirements has always been required of landlords, and we would submit that the same strict compliance should be imposed upon tenants, especially in a commercial lease with a sophisticated tenant. This court's case, find it here. As I said, Kaplan required a demand for rectification. We cited a New York case, which I thought was very similar, and the reason why bothered to cite a New York case, where they said that the notice did not even contemplate a cure of the acts. It just claimed an eviction and said, we're out of here. And that's, I would submit, what this letter indicated. It indicated this is non-repairable, or you're not going to repair it, and we're out of here on or before such and such date, which could have been tomorrow if they were ready to do so. They did not give an opportunity to cure. So even if the court were to conclude that a demand to cure was unnecessary, clearly an opportunity to cure was necessary, and this letter did not communicate an opportunity to cure. In fact, it communicated just the opposite. We're not giving you an opportunity to cure. We're done with this. We're leaving. As to the issue of prior case law and whether the statute controls over it or not, I would just point out that regardless of that issue, the case law that's been cited by appellants does not, none of them address a situation as we have here where there is an express contract provision stating that a particular notice needs to be given. All of those cases simply, they were just silent as to whether that sort of contractual provision was at issue. So they're not on point. They talk about notice. Many of them talk about notice in the context of a waiver defense to a constructive eviction action, which quite frankly I think we might have had here as well, but that's not before this court as an issue. So those are the cases of Barton, Bass, and Bermuda. They weren't even about notice. If you read those cases, they weren't even about notice. There was some language about notice, but that wasn't the issue in those cases. And in fact, the third district, in considering the residential provision, the residential lease provision that's similar to the one we have here, said that a notice of this nature is a condition precedent to urging constructive eviction, and that's a written notice. So we would, as we did argued below, we would argue to your honors that the written notice demanding rectification, actually giving an opportunity to cure within 30 days, not just stating we don't think this is curable and we're out of here, was required. It wasn't provided. And since that is a condition precedent to urging constructive eviction, that constructive eviction affirmative defense was properly stricken. And one final point, the thing that I want your honors to keep in mind on the argument that this is a case law issue, that this contract provision is not applicable, and that the case law says as long as you have notice, that's good enough. The appellant, the law firm itself, specifically hinged its claim of breach on a contractual breach. They specifically cited Section 29, which is the express covenant of quiet enjoyment. So they want to take the benefits of the provisions of the lease, including the express covenant of quiet enjoyment, but they don't want to have the what is negative for them. They don't want to have to comply with the notice requirement. We would submit to your honors that that notice requirement should be strictly applied to them in the same way that a notice requirement would be strictly applied to a landlord. If your honors do not have any further questions for me, I will just ask that you affirm.
All right, you got a little over 8 minutes, sir.
Thank you, Your Honors. May it please the Court. Appellee has conceded that the issue of whether or not the sweltering in the summer and the freezing in the winter was extreme enough to merit a finding, an ultimate finding by a jury or judge of constructive eviction was an issue of fact and would have gone to a jury. She discussed how they would be they were prepared to go to trial on that issue, and perhaps they might have prevailed on that had it gone to trial. We believe otherwise. We believe that the witnesses would have been lined up to discuss how this was a problem replete through the building, how...
Well, I mean, it's a curable breach, though, right? It's not. It's not in the nature of a, changing the locks and or going in and taking off, gutting the place so that the tenant can't. It's not habitable anymore. This is a curable breach, right? That's
exactly correct, Your Honor. It was a curable breach, and that's why the landlord had this
Well,
opportunity.
but I mean, if it's curable, how is it a constructive eviction? How is it tantamount to an eviction?
Certainly. The case law discusses what it means to be constructively evicted. It is not that it is untenable, uninhabitable rather. It is that it is untenable for the intended purpose. That if this was a gym where people are going to be sweaty or they might not mind the cold under other circumstances, that would certainly be a very difficult argument to make. But when you are, the intended purpose, as the landlord was clearly aware, that it was a law firm that was intending to operate as a law firm, to have space heaters and fans and these wildly vacillating temperatures that makes it uncomfortable for the clients who come in, and you're trying to recruit those clients, that does not make for proper tenantability for the tenant, and that's why the cases, including this court's Bermuda Avenue Shopping Center case, discusses specifically what it means to be constructively evicted, and as long as it interferes with the tenant's beneficial enjoyment of the leased premises. It's not that they can't get in, it's not that the roof is coming down on them, which would be a whole other set of circumstances. Instead, it's simply that they cannot enjoy the premises for the very purpose that they rented the purpose. If they were having a warehouse, then they probably would have a very difficult time making that claim stick. As a law firm, if you are going through these wall vacillations and you have made repeated efforts to get a cure, it is a curable situation. The landlord's property manager testified that she had received the 2 different bids, and both times the landlord went, yeah, still not going to do it. That's exactly when a tenant has to avail himself of one of the remedies that are available, and in this instance, he notified and followed the lease provision that allows the notice that unless the landlord then fails to perform that obligation within 30 days after receipt of the written notice thereof. The landlord had, exactly as Your Honor just said, it is curable. Landlord could have cured it then. The landlord could have cured it any time for the prior 2 years. Landlord elected not to, and when it does so at its peril that tenants can walk. And if they walk, then unless the case law prior to 1993 really is abrogated and really does not make a difference anymore, they are allowed to attempt to seek, if they've been paying.
If a tenant sends a letter to a landlord saying, the air conditioning system isn't sufficient, and we've talked about this in the past, and we are leaving, and we're leaving in 30 days, and we're leaving no matter what, and it just doesn't matter, we've already signed another lease and we're leaving. If it's a curable condition, and even if it is a breach of the covenant of quiet enjoyment or the provision in any other provision in the lease, does the landlord have to make the repair in order to recover in damages if the tenant unequivocally says, I'm leaving no matter what?
I answer that question in 2 parts. One, I don't believe that
you can take 3 or 4 parts. It was a really long question. Convoluted, but whatever.
Your Honor, I would simply state that first, that the letter, when taken in context, is not as affirmative as that, and the statements made by Mr. Johnson on deposition still never said, nope, we would have left no matter what. That's not what he said. The statement, it is what it is not what it's been painted to be. But to get to the initial question, which I am, well, the question, I'm sorry, Your
If there's, and maybe this is the wrong term, I haven't seen this term used since law school, but an anticipatory breach. If I write my
Certainly, Your
landlord
Honor.
and say, I've already signed a lease in another place, you haven't corrected this in the 2 years I've been here, and I'm moving in 30 days. Just wanted to let you know what we've done and what we're doing.
Right.
And there really was a problem over that 2-year period. Would the landlord have to fix the problem within that 30 days and be able to come in court and say, see, I fixed it, in order to recover in an action for rent?
Certainly. And thank you for the clarification, Your Honor. And the question, it goes back to the lease language itself, and the parties make the document as noted by the landlord. You've got allegedly sophisticated entities here, so when they drafted 22D to read as it reads, even under that hypothetical, it would seem that if the landlord intends to go out and secure damages for a tenant leaving under those conditions, essentially the landlord would have to prove that the cure was something it had under its ability to do, and that it was going to proceed to do so. And here, the landlord never made any effort. The landlord never tried once to fix this problem, and lost, if the case had gone to trial, it would have shown not just this tenant, but number of tenants over this issue. So I believe that the plain language of the lease still has to control, even if the result seems to be something that would be too harsh on the landlord. But here, the harshness is that it doesn't get to collect future rents for a tenant that could no longer use the property for the purpose that it was intended to be used for. I don't believe that that's harsh, and I believe that the case law supports the right of the tenant to walk under those circumstances. So for each of these reasons, the Johnson Law Firm respectfully requests this court to reverse the improperly granted summary judgment and to allow this case to be remanded so a trier of fact can determine whether or not this was in fact a proper constructive eviction.
All right, thank you.
Thank you, Your Honors.
Thank you for your arguments, counsel.
Thank you.
All right.